having read the affidavit, and I don't know if you've been keeping up with the case and its developments, but just what are your thoughts? Having read the murder affidavit, do you think that there's enough there, and do you think that the state has a solid case to prove this murder?
Well, anytime you have a murder allegation without a dead body, you don't have a solid case. But the affidavit, you have to remember, an affidavit only has to show probable cause. That's the standard for a judge to sign it. It's not beyond a reasonable doubt, which what a jury would need to, government would need to prove that level of evidence to get a conviction on a case, on any criminal case, but especially something as serious as a murder. So does this have probable cause? It has circumstantial evidence in this affidavit. Circumstantial evidence can be powerful evidence. I mean, it's not direct evidence, but it's the circumstances are such that could establish each element of an allegation. Now, when it comes to murder, you have to create a nexus or show a nexus between, number one, a dead body, and they have to prove that a body is dead. That's difficult sometimes when you don't have the body. But again, you can do that through circumstance. You have people that have said in that affidavit that she would never leave her 5-year-old child without calling. There's no evidence of her using her financial resources. There's no phone activity. No one has seen or heard from her. So circumstantially, that can be enough to prove that she is dead. Now, if you have a death, then can you tie it to an individual and identify that individual as the person responsible for that? Well, you look at other circumstances. From the affidavit, they're claiming that he was the last one in her possession, in her presence. The neighbor witnessed them arguing, and the neighbor allegedly witnessed an assault. She broke away. He chases after her. There's a screaming. Then all of a sudden, there's suspicious activity of driving, coming back, going away, turning your phone off during times where she's missing, allegedly lying about what happened to her phone, then going to Home Depot and getting all kinds of things that would be presumptively used in covering up a dead body. Tarp, wrapped up, covered by objects, plastic bags, cement, going to a dump site, talking to a stranger in the parking lot in Kendall County, where's the dump site? And then communication with his friend, I guess some individual named Cotter. That's interesting to me. I want to know what that guy said at some point. I mean, remember, law enforcement and the prosecutorial branch of our justice system doesn't have to put everything in an affidavit. It's just enough to reach probable cause. So there's no obligation to put all their evidence in there. So I don't know if this individual that spoke with the accused has said anything, is cooperating. What has he said? Is he corroborating other pieces of evidence? So this is definitely not a slam dunk case. Do I believe, obviously the judge who signed the affidavit and the warrant believed that there was probable cause circumstantially to make an accusation of murder, but will it rise to the level of beyond a reasonable doubt for a jury to contemplate at a later date?
Say somebody comes into your office with, this affidavit, the facts of this case as they stand right now, and they want an honest assessment. All right, Mr. LaHood, am I cooked? Am I just done for? What are my odds here? What am I looking at? What's your message to that person?
Well, somebody came in with an affidavit like this and these allegations, we don't give percentages because ultimately it's what a jury thinks. Now this is circumstantial evidence. Is it suspicious activity? Sure it is. Does there have to be some explanation to it? I mean, you're looking at the accused who was the last person that had been in her presence. And there was an assault that occurred, allegedly. And I don't know if he's saying that didn't happen or not. I mean, that's going to be part of his defense at some point. But that is evidence. And then she went missing at that point. And you have a third-party witness that saw this alleged assault. And then you have behavior that circumstantially could be proven to be tied to some type of murder. And then obviously the body is missing. And so they're going to say that his behavior is consistent with someone who's trying to hide a body, going to Kendall County, doing all those things. I think there's some challenges. There's definitely challenges. I think a lot of people and legal experts are going to be looking at the technicality. We look at things from a trial firm's perspective in front of a jury of citizens, of the accused peers, and then having explanations. I get that the government's burden. It's their complete burden. They have to prove each and every element beyond a reasonable doubt. But there's a practical side to trying cases as well. Now, There's an analysis for the trial court and what a jury may do. And then there's another analysis for an appellate court and what a potential appeal might, could an appeal be sustained and held up and later on. So those are different analysis. I would never give an opinion based off an affidavit, that supported an arrest warrant. We have to look at all the evidence during the process of discovery. So I would not say anything. I would not give percentages. I would talk to a potential client in this situation and ask them what their answers were to some of these challenging issues or some of these suspicious issues, and then wait to see all the evidence and then come back and then do our own investigation and try to put in some of these pieces to this puzzle. I mean, obviously you have an individual that's missing. You have behavior from this individual that's not consistent with someone who is alive, with the daughter and other people that are in her lives. She's shared with other people, allegedly, that she's been assaulted and been threatened and that she's scared. And then you have behaviors from the accused that are going to be used against him. So I wouldn't make an assessment at this point. I would wait for all the evidence to come in, but there are some challenging facts.
Great. And from that lens, I mean, trying a case without a body is a great risk. Do you think that, just given what we know now, or given all that we know now, do you think that that was an appropriate risk? And I mean, they don't get a second bite at the apple if this makes it to trial and whatnot.
The investigation is not going to end. So the prosecution is going to continue to investigate. When I was district attorney, there was 54 investigators. They work alongside the prosecuting lawyers, the assistant DAs in the office, and they're going to work with the initiating agency that initiated this investigation, and they can continue to gather evidence and see who talks and doesn't talk. So there's an ebb and flow of an investigation when a case is getting prepped to go to trial. Remember, this is probable cause standard right now. So is there probable cause? A judge agreed that there was probable cause of a murder. And so based off circumstantial evidence, which, yes, it still can be strong and powerful, but will it rise to beyond a reasonable doubt in front of a jury? I mean, I couldn't make that assessment even if I had all the evidence, because the jury's going to do what a jury's going to do. You just have to identify what are strengths and weaknesses in your case, and then do your best to deal with both of those. Accentuate your strengths, and then do your best as you can. If you can't answer all the questions with your weaknesses.
Awesome. And last question for me, was there anything that stood out to you about this affidavit, whether it be the investigatorial side or just the legal maneuvering, from the bonds to anything else that anything stood out to you?
It's long. This is a long affidavit, even for a murder. And I think it speaks to the fact that there's not a body. So they wanted to put as much as they could in there to substantiate probable cause for a judge to sign this warrant. So it's long. This is not a typical I think it was 9 pages. I don't remember exactly how long it was, but this is a long affidavit, even for a murder.